but our courts need to be bold enough, and we as a society need to be bold enough to start recognizing marital rape as rape falling under Section 375 of the Penal Code. As I said before, our problem as a justice legal system is not the lack of laws, it's that their enforcement, it's the idea that, or it's collectively us providing women with expedited justice, with, sensitivity, with compassion for what they've gone through. So before we kind of delve into what the judgment says, let's just quickly discuss what the facts of the matter are. So this judgment pronounced by a sessions judge in Karachi, the case is titled State versus Javed. In this case, the victim, Sherbano, alleged that her husband subjected her to forced sexual intercourse, and specifically oral and anal sex, and which is why then she proceeded to file a complaint under Section 377 of the PPC. The judge looked at all the evidence, her medical legal reports, and then also examined evidence put forth by the defense and came to the conclusion that there is enough material on record to prove offense under Section 377, which is the offense of sodomy, and then convicted accused under Section 377 and awarded 3 years of rigorous imprisonment and 30,000 rupees in fine. Now, there has been questions raised about whether in fact this is a conviction for marital rape, how is sodomy different than marital rape. Let's just look at the law first. Under Pakistani law, in the PPC, rape is criminalized under Section 375, which is the general provision that criminalizes rape. And then sodomy is criminalized under Section 377. Now, the language of the provision of Section 377 is carnal intercourse of an unnatural nature with a man, woman, or an animal. Now, essentially, because of the nature of the allegations, because the allegations were, one, that there was forced sexual intercourse, and secondly, the second layer was that there was anal and oral intercourse, the charge was framed, or the indictment was under Section 377 as opposed to Section 375. However, the idea that this is not marital rape per se is slightly misplaced, because if you think about it, this was still a conviction that this act still happened within a marriage, right? Within a marriage, and this is the first known conviction that we've heard about where a man was convicted of committing a sexual offense against his wife. It is a progressive judgment, it is a landmark judgment. However, the next step would be to get these convictions under Section 375, which is the broad provision which covers rape. So essentially right now, what has happened is, because of the nature of the offense, it was put under Section 377. But the next step for us and the real progress will be when we start convicting offenses of marital rape under Section 375. So yes, there is a distinction between conviction under Section 375 and a conviction under Section 377. And in this case, the conviction is under Section 377, which is for sodomy. However, it is not incorrect to say that this is in fact marital rape, because this act also occurred within the confines of a marriage. This was forced sex that a man subjected his wife to. So in that sense, yes, it is marital rape. However, as I said before, our real progress, or this judgment is a step in the right direction, but our courts need to be bold enough, and we as a society need to be bold enough to start recognizing marital rape as rape falling under Section 375 of the Penal Code. As I said before, Section 375 covers the offense of rape in Pakistan, and previously, I'll move on to what the amended version of the provision looks like in just a minute. But Section 375 said that a man is said to commit rape when he has had sexual intercourse with a woman under 5 circumstances. So against her will, without her consent, when her consent was obtained under duress, when her consent was obtained under misrepresentation, the woman believed or that she was married to a particular man, or was made to believe that she was married to a particular man when in fact she wasn't married to that particular man, or with somebody who's under 16 years of age, with or without their consent, that is statutory rape. This provision was amended, or rape laws in Pakistan underwent change in 1979 through the Zina Ordinance, where the definition of rape was modified that it was non-consensual sexual intercourse by a man with a woman who was not his wife. So the implication being that there is no such thing as marital rape. For an act to classify as rape, the two individuals needed to be unmarried or not married to each other. If two individuals were married to each other, any forced sexual act would not classify as rape. So that was the implication that came through the 1979 Zina Ordinance. Then in 2006, we had another amendment to the law, and this language was then modified, obviously after a lot of activism, pushback, criticism to this law. The language of, without his wife, or the I think the exact language was together if they didn't have a valid marriage, that language was taken out. And then through Section 5A, I believe, of the Zina Ordinance, the provision was put in that any allegation of rape cannot be converted into an allegation of zina, which is what used to happen when the 79 Ordinance had come into force, that if a woman was alleging rape and then she wasn't able to prove rape, then courts would consider that to be zina. So then that amendment came in 2006. Now, the latest amendment that we have is it happened in 2021. This amendment has been notified for all of Pakistan, but currently it's not being implemented in Punjab and KP. What this amendment has now done is it has made the definition of rape gender neutral. Previously, as I just said, the definition of rape confined to sexual offences by a man against a woman. Now that language has been made gender neutral, and the language of the provision is person A, if person A commits said act against person B. Instances of what constitutes rape, the specific acts have been broadened, so the language of the provision has been made much broader. So it covers a lot more acts that constitute rape, and it has been made gender neutral. So that's the progression of Article 375 over the years. Additionally, we have additional provisions that have come in. So we have now a provision that covers gang rape. We have a provision that covers child abuse. So this is kind of the progression of laws in terms of rape offences or offences of sexual assault. So obviously, like the law in Pakistan, while there is no specific provision that covers marital rape, now over the years there is enough provisions on the book that cover all sexual offences against women. In fact, I was just talking about amendments to Article 375, and one of the key amendments to Article 375 that has happened through the 2021 amendment is that it now, through its explanation, specifically defines what consent is. Previously, like when you used to read judgments would like look for signs of whether the woman resisted against a sexual act. That would be evidence. If there were signs of resistance on her body, then yes, the resisting against said sexual act, and that would indicate the occurrence of a rape. Now the language of the Article 375 through gesture indicating consent. So that's very, very important, that the resistance is not the marker of consent. In fact, it is an amendment that has consent. Previously, through judgments, we've seen that consent or the lack of consent was equated to resistance by the woman. So if there were no evidence that indicated resistance or marks on the man's body, or any signs on her body that she put up a struggle, that was taken as her having consented, or the fact that these marks existed or there was evidence of resistance indicated that in fact. Through the 21 amendment, through the explanation put under Article 375, consent has been defined to be unequivocal. An unequivocal voluntary agree indicates through a gesture, through verbal communication, through non-verbal communication, their willingness to engage in sexual intercourse. So this is from now we've moved from this sort of negative idea, or not idea. In fact, consent is not putting up a resistance, but consent has to be in fact affirmatively, positively given if somebody is engaging in sexual intercourse. And if that consent was not given, it cannot, then the law presumes that there was no consent, and that then leads to the determination that in fact rape occurred. So that's in fact a huge development in terms of our jurisprudence. Other provisions, there's enough provisions now on the book that covers all kind of sexual assault against women. So our problem as a system that is supposed to provide protection to women against sexual assault is not that we don't have provisions on the books covering sexual offences. Granted that we do not have a specific provision covering or allowing for marital rape, but our definition after the 2021 amendment is broad enough that it covers marital rape. Our problem lies in enforcement or in making sure that when somebody approaches the legal system, approaches the justice system, that they are provided efficacious justice. Now, to that end, we have a new law in place. It's called the Anti-Rape Trial and Investigation Act 2021, which is a fairly progressive piece of legislation. And what it has done is it has introduced a few key things that are supposed to now help expedite justice for rape victims. And I'll just quickly go over a few of the key features. So what it has done is special courts are supposed to be established in every district that will specifically deal with cases of gender-based violence and sexual assault cases. Anti-rape crisis cells are supposed to be established in every district, and what these crisis cells will be responsible for is for the conduct of investigation in an expeditious manner. So conduct of the medical legal text, without any delay, collection of evidence, forensic analysis, registration of the FIR. So it's envisaged as this one window operation where rape victims can go and get all the necessary support that they need. Then the Act also envisages provision of legal aid to victims. So for example, if a victim does not have the resources to access legal aid, to access a lawyer, then under this Act, they will be provided with such legal assistance. Finally, a lot of times women do not approach justice system when it comes to rape offences, or do not report rape because of the social stigma attached to it, because of the idea of going to court and retelling the story and putting themselves through trauma over and over again. So this Act has now introduced the idea of protection of the identity of victim and witnesses, including provisions for their security, concealment of their identity, recording of testimony through video links in camera trials. And then lastly, another key feature is mandates the establishment of special sexual offences investigation units, which will have trained police officers who are specifically trained to investigate special offences, to investigate crimes of rape. In fact, Sindh has actually been made the most progress in terms of implementing this law, and 30 of these special units have been established all over Sindh. And then we also have an anti-rape crisis cell that was the first crisis cell that has been established in Islamabad. So just in terms of our legal, as I said before, our problem as a justice legal system is not the lack of laws, it's that their enforcement, it's the idea that, or it's collectively us providing women with expedited justice, with sensitivity, with compassion for what they've gone through. Focus now should not be on bringing more laws in, but in fact implementing the laws that we already have in the spirit that they're supposed to be implemented in.